Good morning, everybody. I just thought I'd pop in and let you know that the court still has not started yet. The stream went live, and so I went live. As soon as uh, the court starts, the cameras will turn on, and you should be able to hear as well. If when you start seeing people running around and you can't hear anything, please let me know. But I believe everything is shared properly like I did last time. So, but good morning, everybody. I just thought I'd pop in and say hi while I'm sitting here working on my other computer, just listening for things to start. So, how's everybody doing? Are we excited for this trial? Good morning, JL. I'll just say good morning, everybody. Good morning, Aaron, Olivia. You woke up early to watch? That's good. Hey, John Gary. I don't think. Yeah, see, a lot of people think like James is automatically going to get convicted because Jennifer was, but the facts are different. I do say that this is going to be primarily a cut and paste case because for the most part, probably 80% of it, the facts are the same, right? There was a gun purchased. James purchased the gun as opposed to Jennifer, but there was a gun purchased. Um, the fact that James took Ethan shooting to the Rangers, that was already established. The fact that Jennifer took James or took Ethan shooting, that was already established. The fact that Ethan did all these things and sent all these messages and wrote all these notes and drew all these pictures and all of that stuff is all going to be the same. Morning, all. Morning. Hello, Fox. And Josie's in the chat. Welcome, welcome, welcome all. Okay, I'm gonna pop back in the background because I do have work to do. But I did quit. Think of me as more of a producer. I'm a producer role today. So, all right, y'all enjoy.
Recording in progress.
Your Honor, calling People versus James Crumbly, case number 22-279-989-FH.
Thank you. Good morning, Mark Keith on behalf of People.
Good morning. Karen McDonald on behalf of the people.
Good morning, Your Honor. David Williams on behalf of People.
Good morning, Your Honor. Mario Lehman on behalf of James Crumbly, who is standing to my left.
Good morning. Mr. Crumbly, can you hear us?
Yes, I can.
You can see it. I was here last night, and I have a few rulings for you. The first would be about, I believe, about Exhibit 45, 52, and 62. And those all have to do with texts from the shooter, Jennifer Crumbly, during time periods when the defendant and his wife were also taking photos of themselves at a course together. They subsequently metadata the GPS shows. So I reviewed 62, 52, and 45. And the court finds that those texts would not be admissible because they are between the shooter and his mother. There's no information whatsoever, with the exception of the fact that dad is with his wife, as demonstrated by pictures and texts and GPS and metadata and all those things, all those tools that are being used by the prosecutor's office to track people's movements in this case. So they are together, but there's no evidence whatsoever that dad was on the receiving end of that text. And in fact, I know that in both 52 and 62, the statement from Jennifer Crumbly appears, "Where's your dad?" So I don't find that there's support to believe that Mr. Crumbly was aware of these texts. He could have been aware of these texts. We just don't know. And because of that, those texts will not be admitted. And that also makes, I think, some of the information at the horse barn inadmissible. Clearly, if Mr. Crumbly were to testify, or if it became relevant, I can see the prosecutor saying, well, do you raise horses? Did you spend a lot of time with your wife horseback riding, whatever it might be? So the pictures of the defendant and his co-defendant at the horse farm might be relevant and might come in for other reasons. But the texts between the shooter and his mother will not be admitted because there's no evidence that the defendant knew about those. So that's that. I think you then asked me about Exhibit 78. Exhibit 78 is in conversation. I don't recall if it's Instagram or text. And it's between the shooter and his friend. And it's a text that says, "Hey man, times have gotten rough ever since you left. I don't know if you're dead or you moved away, but I hope you're doing well. I'm about to do something really bad and there's no turning back. So I'll probably never be able to see you again. I hope the best for you, and I'm sorry for anything I've ever done." And that's dated November 30th, 2021 at 8:21 in the morning, the date of the shooting. And it's to the shooter's friend, who's been previously not identified by name, but identified in this case. So I read a series of cases, including the case submitted by the prosecutor in this matter, who indicate that there is an exception in this matter. Exact site. That there's not, that this is not hearsay evidence. But I read a series of cases interpreting that issue. And one of those is People versus Stubble. I think it's 149 Michigan at 42. In that case, hearsay testimony was given by a prosecuting witness to testify that the defendant had approached her several times to discuss prostitution. And in that matter, the challenge to the evidence concerning the witness's testimony that one of the older men propositioned her friend. So this text in Exhibit 78 is offered by the prosecution under 8033. 8033 applies as an exception to the hearsay rule if the declarant's state of mind is at issue in the case. That's also stated in People versus Lucas 360 Northwest 2nd 162. Also a Michigan case. This one's from 1984. People versus Lucas. That also says the court's ruling that the testimony was admissible under the state of mind exception to the hearsay rule pursuant to MRE 8033 was also error. Only when the declarant's state of mind is an issue in the case is evidence of his state of mind admissible. In Lucas, they asked about the state of mind of the deputy in the case. And in that case, they determined that the state of mind of the deputy, who was one of the officers in the case, was not at issue. Then there's People versus Fisher, 449, Michigan 441. I believe that's a case that the prosecutor relied on. That case also says, talks about statements and marital discord. In that case was the issue. I believe it was a murder, husband and wife. And in that case, Fisher says, in the case at hand, marital discord, motive, and premeditation are all at issue. Thus, the statements of the victim wife are admissible to show the effect they had on the defendant husband. They were found admissible under a state of mind exception to the hearsay rule. I'm not going to admit People 78 because the defendant's, although the defendant's state of mind in this case might be admissible, the shooter's state of mind is not at issue. We all know the shooter's state of mind on November 30th of 2021. Additionally, there were requests for Facebook messages. I believe those are 160. 161 was ruled on. Am I correct?
Yes, Judge. I think it was 118 and 153.
Was it 133? Was
Oh,
130?
sorry, 118, 133, and 153.
And 153. All right. So I'm not going to rule on 133 right now. There's something else I want to look into, but I find that 118, prosecutor notes 801C. I believe that entire chain is hearsay and does not fall under any hearsay exception. So I will not be admitting number 118. Sorry, Mr. Keys, did you say 153?
Yes, Judge, 153.
Right, I have 133, but I'm gonna pass on that. All right, I'm gonna have to look at 153 again.
It's the last text in the 118 and 153. They're the same text conversation. It's just a different portion of it. It's the last text. It's the text from Jennifer Crumley that says, Ethan, don't do it.
Okay, all right. I can get back to you on that, right? You don't need to know before opening. Okay, so with regard to 133 and 153, I will continue my homework assignment later.
Thank you, Judge. Just want to recap, make sure the record's clear. The court's ruled on exhibits 45, 52, 62 today,
Correct,
78 today as well.
correct.
Yesterday, 308, 321. Those are two different photographs ruled inadmissible yesterday. We redacted photographs 258, 259, and 260 that were an issue. We gave a copy to the defense counsel this morning.
Okay,
We agreed to limit exhibit 80 yesterday. That's the DoorDash text message conversation to just the
okay,
26th to 30th of November.
okay.
And the rest were ruled to be admissible yesterday.
Is that your understanding as well?
Yes, Your Honor.
And the court's reserve on 133 and 153.
133 and 153, and you don't need a ruling before openings for those.
I
right?
do not, Your Honor, and I'm sorry, Mr. Keys, did you indicate 118 was also not admissible?
Not
Rule on
admissible.
I
today.
should have, yes.
Okay,
133 and 153. I also wanted to ask you, there was some discussion yesterday that members of the media have requested a copy of the questionnaire that was provided to the jurors. I don't have a feeling about it either way, but if you agree to release it, I will. If you don't, I won't. So I don't.
I really don't have an opinion. Now that the jury's impaneled, I don't see an issue. Why not?
the defense also does not have an opinion on it, Your Honor.
All right, so anybody who wants one can email the chambers and we'll give that to you, all right? So, bring the jury in.
I have one more issue. When we were approaching,
Can I ask you to turn the mic off too? I think there's been some issue with it being picked up. Thank you. All right, so can I bring the jury in? You guys good? Can I swear them in, all those things? Ready?
I'm sorry, can we go one more,
Sure.
just briefly, I'm sorry, related issue.
Okay, can you guys turn up the microphone again? All right. Can I bring the jury in?
yes, sir.
Okay, I'm gonna give them some instructions. remaining, I guess I'm gonna ask you to remain standing because I'm going to swear you in. All right? Can you all raise your right hand? Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm going to ask you to swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you're discharged by the court and from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. Thank you. You may be seated. I appreciate you being on time. I do. I have to give you some initial instructions, and then you're going to hear opinions today, all right? And don't try to write down what I say because I speak way too quickly, and because you're going to get a full copy of these instructions when you go to the jury room, all right? I'm going to explain to you some of the legal principles you'll need to follow during the trial. I want to tell you the elements of the charge. The defendant is charged with 4 counts of involuntary manslaughter. The prosecutor has alleged 2 separate theories of defendant's guilt, which may be established under either or both of the two theories. The first theory of involuntary manslaughter is doing a grossly negligent act causing death. To prove this charge under the first theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, in count 1, that the defendant caused the death of Madison Baldwin. In count 2, the defendant caused the death of Tate Muir. In count 3, the defendant caused the death of Hannah St. Juliana. And in count 4, the defendant caused the death of Justin Schilling. That is, that Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. Second, in doing the act that caused Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, we must find each of the following 3 things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. As previously noted, the prosecutor has alleged 2 separate theories of defendant's guilt. The second theory is gross negligence in failing to perform a legal duty. In the second theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to prevent their minor child from intentionally harming others or prevent the minor child from so conducting themselves in a way that creates an unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin as to count 1, Tate Meir as to count 2, Hannah St. Juliana as to count 3, and Justin Schilling as to count 4 were directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent him from intentionally harming others or from so conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he has the ability to control his child, knowing of the necessity and opportunity to do so. There may be more than one cause of death. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act or failure to act. With respect to the alternate theories, it's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. I've just described some of those to you, and you'll hear them over and over again. And they'll also be in your jury instructions, the written set that you get at the end. Every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. I want to mention that you see cameras in the courtroom. I don't want you to be concerned about those. The video cameras and the still cameras will not be taking your picture at any time. So I want to make sure you know that. A trial follows this procedure. First, the prosecutor makes an opening statement. The prosecutor gives their theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or she may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents their evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, they are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. Sometimes I assume if I'm confused about something, someone else on the jury might be. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. If you can't hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I'll rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the case. The lawyers and I will definitely have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I'll send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are here. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you're a juror and that you're not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. I mentioned before that it's helpful. I guess I'm hopeful and it's helpful that you wear your badge because that sort of alerts people in the courthouse that they shouldn't be chatting you up, okay? All right. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instructions. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider has to meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now, well, really yesterday, and continue until I discharge you from jury service. It's your duty as a juror to decide this case based solely on the evidence that you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event in this trial. If it's necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other matter. If you discover that a fellow juror has violated my instructions, please report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must give them to my clerk when you leave each evening. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. It is possible to replay a witness's testimony upon your request. I think I mentioned this to you yesterday. However, you would be required to hear the entire witness's testimony. You can't fast forward to a certain part and all yell, aha, okay? It's not fair to both sides. You would have to hear that entire witness, all right? There's more than one defendant involved in this matter. You should consider only the evidence presented in this defendant's trial. Each is entitled to have his or her case decided on the evidence and the law that applies to him or her. You can see that there are 15 of you. We have you in 2 different jury rooms just for comfort. After you've heard all the evidence in my instructions, we will draw lots to decide which of you will be dismissed to form a jury of 12. Possible penalty should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. I'll definitely be giving you more instructions throughout the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I'll give you additional instructions about the rules of law to apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you'll go to the jury room to decide on your verdict. The verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to maintain an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. All right, so we're going to hear openings. Prosecutor.
November the 30th, 2021, James Crumbly's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbly's son walked out, he pointed, he aimed that 9mm, he fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized the entire community. James Crumbly bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbly failed to secure that gun in a way to prevent his son from accessing it. Autumn was 14 years old. Madison Baldwin, she was 17. Tate Muir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home that day. What happened inside that school was truly a nightmare come to life, but it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible, but so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbly, her case is done. You're here to decide the level of gross negligence of James Crumbly. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbly seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. During this trial, you're going to hear about events from the spring of 2021 through December of 2021. November of 21 is the critical time period, especially November the 30th. But that earlier evidence is going to give you some context into the family life in the Crumbly household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap. What happened was foreseeable, especially to his father. I'm going to talk to you about some of the evidence that you're going to see in this trial. And we'll start with this. This is a 6-hour 9mm handgun. This was the firearm purchased by James Crumbly as a gift for his son on November the 26th, 2021. This is a picture taken by the shooter, found on his phone, the day that gun was brought home. This is an Instagram post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun. Took my new SIG out to the range today. Definitely need to get used to new sights, LOL. This is a post from Jennifer Crumbly, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and son day testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. You're going to learn that it wasn't just those 2 extra magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase. You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time. You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April 2021. You learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range, even buying himself a .22 caliber Kel-Tec semi-automatic pistol, and his son a different gun, .22 caliber 2-shot Derringer. That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see some of that. Some of this background is going to shed light on what happened in November of 2021. This is a pivotal month in the Crumbley home. As I said, the shooter had one and only one friend. That was no secret. James knew about that. You're going to see evidence that the shooter and this friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he didn't work. It was also during this month of November that the defendant's son began to write in a journal. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he's able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that Sig Sauer 9mm handgun for his son on November the 26th. And then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest, the most glaring opportunity to prevent the shooting. A full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbly. You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbly, who shared it immediately with James Crumbly before they arrived at the school. The severity of the situation wasn't lost on James or Jennifer Crumbly either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbly, she's in blue. Call now, all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband, James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbly's response, "My God, WTF." And then he says what he was actually doing that morning. "Vet not here. It's McElmurray's Procura's horse. Still waiting on the vet." You see, James and Jennifer Crumbly spent quite a bit of time away from the home, tending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbly, he said he was distraught about last night. James, we talked about it this morning. You talked to him? Jennifer, can you call? Then heading to his school, I'm very concerned. That was at 10:04 in the morning. Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbly and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbly didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the Sig Sauer 9mm. They didn't say anything about the prior request for help. James Crumbly didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting, though. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbly get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbly didn't do anything. Jennifer Crumbly didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. It was one of the most glaringly missed opportunities. Instead of seizing that incredible opportunity that was before him, James Crumbly spent the next 2 hours driving around town making deliveries, never once bothering to stop by his house, which was just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so, never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbly about 1:10 p.m. And by pure happenstance, James Crumbly was at the exact location that parents of Oxford high school students were told to go in case of emergencies. The reunification point is the mire on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. you will hear that there was one and only one person who called the police that day to identify their kid as a suspected shooter. It was James Crumbly. This nightmare, these murders, were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I do need to tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbly. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time the first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbly life. You're also going to learn what James and Jennifer Crumbly did after the shooting. Evidence will be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes. What you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbly knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbly gave his son that firearm hoping he would murder 4 students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's 2 reasons. First, it's important to remember that James Crumbly is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation in an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case. It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the 3 elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually 2 different ways to find this defendant guilty of involuntary manslaughter. You are able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. That gross negligence caused death, and not the cause. It was a cause of death. And that's important because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is a failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act, right there is his willful disregard of danger, right there. You're going to hear a lot of evidence and arguments in this case. It's important that we all understand that you're not here to decide on parenting. This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do. That is when that rare set of circumstances is present in the specific set of facts. James Crumbley is in charge with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured, when shown this picture. That's what this case is about. When this kid was begging for a more deadly weapon, that's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged. Thank you.
Thank you, Mr. Case. Ms. Lindler, would you like to make an opening statement at this time?
Yes, Your Honor. Thank you.
Go ahead.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbly knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbly was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbly's mind. Ladies and gentlemen, you will not hear that James Crumbly knew what his son was going to do. You will not hear that James Crumbly even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbly. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbly did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbly purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbly knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbly's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbly and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbly, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbly's son, about Mr. Crumbly's interactions with his son. Yes, James Crumbly was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues, but you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021, and their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbly not guilty. Thank you.
Thank you, Ms. Lehman. Should I give them a little break?
We have a little break.
I'm going to give you a little break, so you might have to do a little bit of setup in the courtroom, and then you're going to hear the first witness, okay? So for about 10 minutes, about 5 at a time.
All rise for the jury.
My counsel, I approach briefly when the jury's out.
Yeah, can you turn the microphone off?
We're breaking down, right, Judge?
Yeah, I'm just trying to get rid of some paper.
All right. While we have a few moments of downtime, I just wanted to pop on and talk a little bit about the defense opening. I'm going to be more focused on my notes and my reviews with the defense's case because that's really going to be the big difference. They're arguing knowledge, which is the exact same thing that Jennifer Crumbly argued. However, I feel like it was a little more consistent, a little more to the point. There was no Taylor Swift arguments. There was no stumbling through the opening statement. I don't know. We'll see if it works with this particular jury. I mean, because that's fundamentally, I think, the big issue. Did they know? Did he know? Did he have any reason to suspect? I do like that she pointed out it's not about what happened in the school. It's about what happened outside of the school. I think that's going to be important. That was a great way to say, yeah, you're going to see a bunch of videos about what actually happened, but don't focus on that. Focus on what happened outside of the school. And so hopefully the defense um, can get that through to the jury. We'll see. All right, those are my thoughts. And hi, Farrell, Baker, and Jamie.
Your Honor, calling People versus James Crumbly, case number 222799989 FH.
Thank you. Good morning. Mark Hughes on behalf of people.
Karen McDonald on behalf of the people.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbly, who is standing to my left.
Ready for the jury?
We are, Your Honor.
All rise for the jury.
You may be seated. Prosecutor, who's the first witness?
Molly Darnell, Your Honor. May I get her in the hall?
Sure.
Oh,
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? Could you step up and have a seat? And would you state your name for the record and spell your first and last name?
Molly Darnell, MOLLY DARNELL.
may I proceed? Good morning. May I call you Molly? Okay. And Molly, I know you testified a couple times. So, keep your voice up. And if you want me to slow down or you don't understand the question, just let me know. Okay. Can you tell the jury what you do for a living?
I'm an educator.
Okay. And where are you employed?
I'm employed at Oxford Community Schools. I've been there since the fall of '98.
So that would be your whole teaching career?
That's correct.
Okay. What is your role now?
My role now is I am a virtual teacher with Oxford Virtual Academy. I'm a mentor teacher for middle schoolers.
All right. So do you go to the high school now?
I do not.
All right. Can you tell the jury what your role was and which building you worked at on November 30th of 2021?
On November of 2021, I was the International Baccalaureate Coordinator for the Middle Years Program, which was a 610 program, as well as the English Language Arts coach, which was a 612 position.
Okay, so you didn't have, did you have instructional contact with students, or was it more teachers?
No, I worked with teachers, predominantly the English Language Arts department, but I worked with many other teachers throughout the 612 curriculum. It was it's a coaching job. So instructional curriculum, that type of what's happening in the classroom at that point in time.
When was the last time you had a traditional teaching schedule?
A traditional teaching schedule, might have been 2015. I'd have to really go back and look at my resume to know that.
Okay,
But in the fall of 2020, I did have a classroom. We went back face to face. And so we pulled all of our instructional coaches out to teach a few hours of the day so that we could spread students throughout the building and get students back instructionally.
okay, so after COVID, the coaching faculty
We moved back
started,
into our.
started to take more teaching assignments so that you could spread kids out. Is that, do I have it right?
Correct.
Okay. On November of 2021, were there kids in the school that you knew? And if so, how did you have contact with them?
There were kids that I knew from the class that I had had the previous year. There might have been, having been in the district for a long time, there were a lot of teachers who had children that were in that building. So I knew a lot of them too.
Okay. I'm glad you brought that up. Does Oxford have a lot of faculty who send their children to the district?
Yeah, I would say many of our faculty send their students through Oxford schools, yes.
Okay. And the kids that you knew in that building that day, did you also know them from middle school with this, or you just knew them?
Yeah, just knew them from knowing their parents, and or if I had them in class the year before. But there might have been a kid in passing that I met here or there, but for the most part on that year, I had no contact with students other than, if like a kid wanted to stop in and see me, or if we met in the hallway, or.
Okay, but did you have a traditional classroom on?
I did not. I shared an office. It was like a half classroom.
So was it a classroom turned into two offices or an office?
Correct. It was a classroom turned into two offices. It was in one of the instructional halls, the math science instructional hall. And I shared it with two other coaches in the district.
Okay. You're the first witness. So the jury's not seen a map of the school.
Mhm.
So I'm gonna put that up in a minute.
Okay.
It's already been admitted. There's no objection to that. But before I do, can you just generally describe how the school is laid out? It's a fairly new building, correct?
It is fairly new. The main part of the building was opened, I think, in the fall of '98, the year that I started with Oxford Schools. And then I think it was the fall of '04 that we started, that it became the high school. So it's a fairly new building. There is like one main hallway that kind of runs up the center and it hugs into the courtyard. It almost reminds me, like if you opened it in a map, you would see it almost mirrors itself in many ways, especially the area that I was in.
Okay, and your hallway were the hallways organized by subject matter?
Yes, we had like our foreign language hallway, our English language arts hallway, we had our math section, social studies, and then science wrapped around the side. Our electives were on the outskirts of the high school.
And how did the students and the faculty refer to bathrooms and exits? How did they describe them from one to the other?
It might have been like the exit by the staff parking lot. That's how I knew them.
Okay.
I know that there are numbers on all the doors. Numbers are not my thing.
It's your English. Where is this? Is there a senior
There is a
leisure
senior,
area
yes.
at Oxford?
Yes, so right up that main corridor, which is like, I said, if you folded it, there's like this one main hallway. Right in the center of the building is considered the senior window. And that is right in front of our courtyard, one of our courtyards.
And the hallways, the subject matter, did you typically find upperclassmen, lowerclassmen, or it was all mixed in all throughout the building?
Well, many of the seniors did hang out in that area, or kids throughout the building. There was no area specific for like freshmen, sophomores.
All right, I'm going to show you now and the jury what's been admitted and marked as People's Exhibit 9.
Can I have this?
Yes, it usually takes 6 minutes.
That goes on last. It'll take a second.
You see it?
Yeah.
Can you tell the jury what we're looking at?
This is a map of the high school. And so you see where it says media center in the middle and then court right below it. we were talking about that senior window,
Right there?
correct? So that senior window is just south of Court, like that's the senior window, that window that is on the south end of Court. No, go back. Yeah, right on like the south end of Court, sorry, south.
Okay.
Am I saying, maybe I'm directionally challenged?
I think.
I'm sorry,
Everyone has
I'm
to
gonna wanna
just-
go north.
Okay, so what,
This would be east.
what was the number for your classroom?
My number is 222,
Okay, and we'll. Right there?
correct.
Okay. And then what's in the middle area right there to,
Actually, sorry, I'm not 222, I'm 224.
okay,
I was right next door to 222.
do you see 224?
You can't see the number, but you can see between 226 and 222.
222.
Yeah,
Okay.
there's a bunch of names written in that. That was all the coaches,
All right.
myself, and the other
And
coaches.
to the left of that, what is that area?
The other room on the other side.
That. Yeah, done. What is this area? What's in there?
That area on the lower end is the science labs. On the upper end, there is I can see a bathroom to the right, a student bathroom.
And the senior area is up
It's up
in the middle?
Yep, it's right there.
Okay.
Yep.
All right. So I want to draw your attention to around 12:50 on November 30th, 2021. Do you remember that day?
I do.
Okay. Did you have any kind of teaching assignment on that day?
I did not have a teaching assignment on that day. It was a Tuesday after Thanksgiving.
Okay. Can you tell the jury about the Oxford lunchtime schedule? Because it's a little confusing.
We run a 7-period rotating schedule, which means that kids meet for 6 class periods a day. The lunches have a split hour, so they have an A, B, and a C lunch. If they're A lunch, they go to their class the second half. If they're a B lunch, they go to class, have lunch, go back to class. And if there's a C lunch, they go to class, then they go to lunch.
Okay, and about how many minutes is passing time generally?
I want to say it was 8 minutes.
And what did you typically do during passing time?
During passing time, I might have gone out in the hall and chatted with a colleague or two, checked in on something. That is also a time it's like the time that teachers need to get things done. So there might be a quick interaction. I might, see a kid in the hallway passing by. But pretty often, like it was just standing guard outside my room or standing outside my room.
Okay. At around 12:50 that day, do you remember what you were doing?
Yeah, a student that I had in the fall of 2020 wanted to chat, and so she came in and we chatted for a few minutes, and then she left.
Do your as a general rule, do you keep your door open or closed?
Open.
All right, and your classroom, as we see in the map, was smaller. What was the layout of the classroom? Were there traditional student desks in there, or can you explain to the jury what the classroom was like?
If you walked in straight ahead, you would have seen my desk. To the left of that, you would have seen one of my colleagues' desks, and then just on the wall like closest to the hallway, there was another coach's desk.
What is at the back of the classroom when you go in the front? The wall you're facing, what is that?
There's a large window that leads out to the courtyard.
Okay. Once the student left, what did you do?
There was a few minutes left during passing, and so I walked around to my desk and opened up my laptop.
All right, and we're gonna
and
see.
check some emails.
Okay, and are you facing the door or?
I'm facing the door.
Okay.
Correct.
All right, and what happened next, Mel?
I'm sitting on my laptop, reading through an email. The door's open and I notice a group of kids running by. It was a movement that I had never really seen before. They were moving, like there was a hyperness to the voices. And it was almost like they were pushing forward, like trying to move as fast as possible.
And that seemed unusual to you?
It was very unusual to me, yes.
Okay, why was it unusual?
I have never seen a group of students move like that before.
Because of their speed or the way that they're,
I think it was all of it. There was a speed to it, the tone of voice. There wasn't any like, my first instinct was that it was a fight, but a fight, because it was the only thing that, was the closest to what students would be moving quickly or swiftly to, especially in that large group of kids.
did you stay seated or did you get up?
I got up. I exited the classroom or the office and moved about
In the hallway?
into the hallway. I moved into the hallway to see what's going on.
Okay, if you look at the map, which direction did you turn? Did you turn
I
towards door
turned
4?
towards door 4.
Okay.
So I turned towards door 4.
What did you see in the hallway?
I see, so the hallway kind of bends. So I come out of my office and I'm closer to that 221, but not fully there, right? I'm closer to 221 and I'm looking and I can see all these kids rushing out of door 4, which didn't make sense to me because again, I'd never seen this happen.
That's what you saw. Did you hear anything at that point?
It was silent. There was no noise.
Was that unusual?
Absolutely unusual.
Okay.
At that time, yes, absolutely.
And what did you do next?
I moved back into my classroom, trying to understand what's happening. And I walk back into the classroom and I'm thinking, okay, could there be a prank? I doubt there would be, and so it's probably 10 seconds, if 10 seconds. And I hear 3 things really close together.
Okay. What did those 3 things sound like?
One was an announcement, the bells chiming in an announcement of our principal coming over the PA and saying, we're moving into lockdown. This is not a drill.
Okay, when you, as a faculty member for this many years, what is lockdown? What have you been trained to know about that? What does that mean?
So we're trained in the Alice protocol, which means we have to use our senses to figure out what's happening. But with all of those students and with what I was hearing, the 2 additional things that I was hearing was like a loud pop, 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 and then multiple doors slamming. I moved to shut my door, and lock myself in.
I want to stop for a minute. What is your experience with firearms up until this point?
Up until this point, my experience with firearms is limited. I have, however, shot a weapon, and I have in my life shot a weapon.
Okay. Have you been to a range before? Is this a hobby that you have?
It is not a hobby. I have been to a range.
Okay. When you heard the pop, 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 what did you think?
I thought in my head I could have mistaken them for lockers slamming easily. They did not sound like gunshots to me, but I'm not really, I've been to a range once. I've not I don't really know what a gun sounds like.
Okay, so what, you said the three things, the announcement,
The announcement, the pop, pop, pop of a weapon, that I now know, and doors slamming.
okay. And what did you do?
I moved to shut my classroom door because when I had come back in, I had not shut it. So I shut that classroom door, and we have a night lock next to all the doors.
Can you tell the jury what a night lock is?
A night lock is a device that slides into the door.
Where do you slide it?
You slide it in the bottom of the door, and it keeps the door. So on my office and all of the rooms in the building have glass partitions on the side. So if someone were to shoot out that and try to get in, it would keep that door from being opened.
Okay, I'm gonna show you what's been admitted as Exhibit 10. Molly, what is that?
That's the office that I had.
Okay, so that's your door open?
Yep.
All right, and where is your, this is not a pic, is this a picture that adequately reflects the normal,
No,
like, okay.
this was.
We're gonna get to why that's like that, but where is the desk that you were sitting at?
Straight ahead, there's that tall lamp. My desk was over way.
The other way, yeah, right there, okay. So, you said you approached the door, you shut it,
I did, I shut it.
and then where was the night lock?
It is in this photograph. You can see that bag that's mounted to the wall. It was, yep, that's a blood bag that we keep in all the classrooms. And then, or like a medical bag or whatever. And then just in front of that, you can't even see it. It's so close to the door,
Okay,
was the night lock.
okay, and I think I might have interrupted you. What is significant about the night lock and why is it used in a lockdown?
It's a measure, it's an additional measure of barricading yourself into a room if need be.
Can you open the door if the night lock is installed?
You cannot,
What about if you had a key to the door?
wouldn't matter. You cannot open it. It's like, it keeps that door from being opened. You would have to remove that metal frame in order to get that door off.
Okay, and how do you, so the person from the inside has to disengage the night lock, is that,
Yes,
do I have it right?
Yes.
Okay, so, you close the door and you get the night lock, and then what happens? Did you see anything in the hallway as you approached your door?
No, I didn't. I shut the door. I can hear that door shutting. It's completely silent. And I grab the night lock. And I look down at it because depending on which way your door opens, depends on how it goes into the door. And I see in my peripheral vision some movement. And so I look up, and in that moment, I see someone wearing dark, baggy clothes.
And are you seeing him through that window right there?
Yes,
Okay.
through.
You describe the person.
The individual is wearing a hoodie, baggy clothes, a mask, and there was a skull cap on, or like a.
So were any parts of this individual's face visible?
I did not see any. Only his eyes, and he was wearing glasses.
Okay. Had you ever seen this person before?
No.
All right. And when you looked through the door, where was this person? How was he facing? Was he facing you? Was he to the side?
At the moment that I locked eyes with him, we were standing square to one another.
Okay. Tell the jury about locking eyes with him and what you saw.
So I lock eyes with this person, and I see some movement coming from the side of him, and I realize that he's raising a gun to me. I remember thinking in my head, there's no orange tip on that gun.
What does that mean?
I had heard somewhere in my past that BB guns have an orange tip. And my body reacted and I jumped.
You're
To the
motioning,
side,
you're
yes.
motioning that you jump to the
I
right.
jumped to the right, so I'm jumping this way in the room.
And at this point, the door is closed.
The door is closed, yes,
Is there a window on the other side of this door or just what we
No,
see?
just
Okay.
what you see.
All right, you jump to the right and then what
I
happens?
jump, I'm turning and I'm jumping to the right, and then I feel my shoulder move back. It feels like I've been stung by hot water.
Okay, you're pointing to something. What-
Yeah,
can
on
you
my
just-
arm,
On your left arm,
yes.
okay.
At
At this point, did you manage to get the night lock in already?
no, the night lock's in my hand.
So he could have just opened the door.
The door was locked,
Okay.
like the lock was
Okay.
on it, right? I look behind me and I see, you can see the bullet hole in the glass leading out to the courtyard. And in my head, I remember thinking a BB gun can't do that. Oh, the instinct in my body was that I had to barricade this door. But I'm afraid to go back to the door to put the night lock in.
Okay, I'm sorry, Ma, I have to stop you for a second. After you locked eyes and you see a gun, do you hear anything?
Nothing.
Okay,
Oh, well, sorry,
that's okay.
it's totally silent in the hallway, but I do hear 3 loud pops. You could feel the force like coming, like the way the door hit, it was very forceful, but the sound did not match the force.
What do you mean by that?
It was like higher pitched than the power of what was happening through that door.
When you jumped to the side, you said then you looked and saw the bullet hole, and then what did you do next?
There was a filing cabinet over on this side of the door against the wall, and so it's like a longer one, and so I grab it and I'm trying to move it, and I'm realizing I can't move it, but I know I have to get back and barricade that door.
Okay. You were shot that day.
I was.
Okay. And can you tell the jury and show the jury where you were shot?
Yeah. I'm gonna remove this.
That's okay.
You can step down if you want to, it's up to you.
So you can see it's kind of like on the back side of the arm. It's not straightforward. Like you can't see the scar when I'm standing straight forward. So he caught me when I'm jumping on this side. He catches me.
And are there
There's
two?
an entrance and an exit wound, and the line in the middle is where the bullet cauterized my flesh.
You can sit down. When you were trying to move the filing cabinet, at this point, did you,
I'm okay.
did you know you were shot?
I did not know.
Okay, were you feeling anything physically?
No. There was nothing physical. I was so focused on, I have to barricade this door. And when I realized I couldn't move that filing cabinet, I still had the night lock in my hand. And so I got down on my hands and knees and I crawled the length of the door and I dropped the night lock in. And it made that like ting sound when it hit the ground. And then I went.
Talk to me about why do you say that it made a sound? Was that significant to you?
The only thing that I have to go on right now is what's happening in my space and what are my senses telling me. It just sticks.
Was there anything, could you see, smell, or hear anything else outside of your door?
There was a smell of a cap, like a cap gun might have smelled like, but I'm not going back towards the window, right? I'm just dropping that in. And then I grab the rolling cart, which is also against that back wall, and I push it, and that's what you see in front of the door.
So that piece of furniture is a rolling cart?
Yes,
Okay, and you could move that?
yeah, it was really easy to move, it was just a push.
Okay. At this point, did you know you were shot?
No,
Okay, what happens next?
I'm concerned that he's gonna come back around to those windows. So I know that I need to hide in that room,
When you say those windows, the front ones or the back ones?
the back ones.
Okay,
In the back, so I barricaded the door. I'm trying to make myself invisible in that space. So I go back to that large filing cabinet and move it just enough so that I can crawl behind it.
and we can't see that here because it's to the left, so would you be able to see, would somebody looking in the window next to the door be able to see you?
No, the cabinet was quite large and it was wide. They would not have been able to see me behind that cabinet.
Okay. At this point, did you realize you had been shot?
I knew I could start to feel blood rolling down my arm. And
What kind
I
of,
don't think I was admitting that I was shot, right? It's not something, it was so far out of what I knew to be what happens. And so I just knew that if I was bleeding, I had to put a tourniquet on. But I can't get back to that bag that has medical supplies in it. So I removed my cardigan that I was wearing that day. And I used one of the sleeves to tie around my arm, put part of it in my mouth and the other part in my hand, and I just tightened it around my upper arm.
were you feeling any pain at this point?
No,
Okay. The person that you saw raise the gun and shoot at you, did you, looking back then now, what was your impression of his use of the firearm, if anything?
Your Honor, I'm going to object to that question. She's already testified she's not very familiar with firearms. I think that she would be speculating about his use at this point.
Yeah, I do want to acknowledge she's testified twice before, so I do know, I'm trying to, this is difficult. Even though it's her third time, it's very hard for her. And so I'm trying to get her to answer my questions.
Well, describe
Yeah.
what you noticed about him.
his feet were about hip distance apart. His shoulders were square. And he raised that gun right up. It was probably a second from the moment that I locked eyes with him.
Okay, just for the record, you're raising your arm at a shoulder level. Was it 2 arms or 1?
I don't know. I just remember seeing the one arm and my body instinctually moved.
Okay. So after you tied the tourniquet, what did you do? Were you hearing any announcements? Did you have a phone with you? Did you have a way of communicating with anyone?
I had my cell phone. The thing that I know to do is to barricade and listen. So I'm trying to figure out what to do next. I know that if we're in lockdown, 911's been called. There's a phone on that desk, but if I reach for it and he's there, he'll see me. And then I'm worried about what's happening in the front office. So I don't want to call up there. And I text my husband, I love you, active shooter. Within a few,
Did you let anyone know that you had been shot?
no, not at that point. Within a few minutes, I received a text message from my daughter who went to school in a neighboring district. Through social media, she had heard that there was an active shooter at Oxford High School. She said, "Mom, are you okay?" And I said, "I'm sheltered in place. I'm safe. And I love you." And I'm just listening to what's happening outside, trying to distinguish what's my next move.
What are you hearing?
Absolute silence. I'm hearing nothing.
Were there any announcements?
There was another announcement that came on at one point, and it was to remain in lockdown. There's a hallway text thread that we have that there's no one texting on that. But
You mean the teachers
Yes,
in that
in the
hallway have a group text?
Yes.
Okay.
No one's texting on that. But in the other part of the building, my language arts team says, I'm hearing there's an active shooter. And I said, I saw one.
Do you say, "and I've been shot"?
I did not say that I was shot.
Okay, is there a reason you're not telling anybody that you've been shot? Is that because you didn't want to really understand it, or?
I think that there's definitely a part of me that was in denial about what was happening in that moment. I also think that what I know is that building has to be secured to save the most amount of lives. And telling anyone that I'm shot when I'm not, when I do not need help, is not beneficial.
So you didn't want anyone to help you?
I did not need emergency medical attention at that moment. Or at least that's what I felt.
Okay. How long do you think you were in that classroom behind that cabinet?
I'm in there for about, I would say, 20 minutes. And I'm sitting on my bum. And at one point I hear footsteps in the hallway because my back's facing that hallway. And I think they're starting to evacuate those rooms. That was the decision. That was the moment I decided to text the teacher next door to me. She's in room 222. And I just said, no one knows right now, but I think I used the word hit. I've been hit in the arm. And then I did say, I hope there's no one else. She then alerted. I believe she called 911, and there was another teacher in the room with her, and he alerted the front office.
So at some point, did somebody come to try to help you?
It was pretty quickly after I sent a text message to them that Kurt News, who was our assistant principal at the time, that he shows up at my door knocking, Molly, are you in there? And from behind that filing cabinet, I said, yes. I've known Kurt since I started in Oxford, but I didn't trust that was Kurt in that moment.
So you didn't want to open the door?
I did not want to open the door. It felt safer to stay in there. And then a few seconds after, there's police officers at the door, and they're like, are you injured? And I said, yes. And so they asked me to, I think I said, do you want me to, I kind of like crawled out from behind, and I was like, do you want me to take the night lock out? And they said, yes. Do you want me to open the door? And they said, yes. And I'm still on my hands and knees at this point. And I reach up for the handle. And that door swings open, and they grab me from under my arms. And they pull me up and out of the classroom. And I can see Kurt standing on the lockers, like against the lockers.
Okay. I'm gonna show you what's been admitted as exhibit 11. What is that, Molly?
That's them at my door. And that's them walking me out. You can see that there were multiple police that were around that door when they pulled me out. And then the two escort me out door 4. We get outside of door 4 and the one says, I'm gonna put a real tourniquet on you now. It might hurt a bit. And then,
Is that what's happening right through the window? You can see in the video?
Yes.
Okay.
and then they said, we're gonna call and see if there's an ambulance available for you. We need to know if someone needs it more than you.
Okay, when you came out, we see somebody there, an officer with a weapon. Was there anybody else in the hallway? Were there any students?
There was no one in the hallway. It was completely silent with the exception of a walkie or two that was going on.
And what information did you have at that point about the shooter? Or did you know if somebody, if they're still in the building? Did you know if there were victims? What did you know?
I have no idea about anything, but when he says, we're gonna see if there's someone else, I think it was the moment that I knew that there was someone else.
When you got outside, what did you see or hear?
There's a helicopter flying above the building. There's a couple snowbanks.
Did you see any students?
There were a smattering of people throughout the parking lot. I honestly couldn't tell you if they were students or parents.
Okay. Eventually, did you get into an ambulance?
I did.
And where were you taken?
I was taken to Lapeer hospital, the hospital here.
Okay, and what happened when you got there?
We get to Lapeer and I asked to walk in. I felt like if I could walk, I wanted to walk. And so they supported me to walk me into the hospital. And as I'm walking in, the hallways are lined with doctors and nurses. Like they were prepared for a disaster.
Okay. What did you learn about your injury that day?
It was through and through. It was clean. They ended up doing a chest x-ray on me in the hospital to make sure that no debris from the bullet came in. And that was probably the first moment that I cried because I felt like I had made a mistake in the classroom and that I had actually put my life in danger. I didn't know if I was hit somewhere else.
What do you mean you thought you made a mistake?
I didn't know if I was hit somewhere else. I couldn't understand why they were doing a chest x-ray on me.
Okay. Were you released that day?
I was. My husband came up to the hospital to come get me. We went home that night.
Okay. At some point, were you informed or shown where those shots landed?
Yeah. He was aiming to kill me. Those shots were intended.
Okay. I want to back up. When did you learn where those shots landed, other than you knew it hit your arm?
My husband was my nurse at home, taking care of cleaning my wound. And at some point when, I'm holding it out, I realized That's a heart level. And he was aiming,
Okay. How many inches is it from your heart, Molly?
I would say about 6.
Okay. At some point, were you shown the picture of your door that depicted? Okay,
Yeah.
do you remember when that was?
Yeah, I saw that photo, in your office.
Okay, when you came in months ago to talk about the testimony. All right, Molly, I'm showing you what's been admitted as Exhibit 12. Is that the classroom, your classroom door?
It is.
Okay, and the pink rods, do you know what those indicate?
The bullets that came through the door.
Okay, and when you saw that in my office, what did you say?
He was aiming to kill me. That's a shot to the head and 2 to the chest.
Nothing further.
Molly, can I ask you to tell the jury what Alice is?
Oh, thank you. Alice is a protocol that we follow. If I could remember the entire acronym, I would tell you, but it's like, we have to listen and make alert. We have to make a decision. Are we going to lock down in place? Are we going to flee the scene? Or are we gonna have to go on the attack, that like someone would come in the room? So it's just kind of dependent upon the situation and what decision we choose to make in a situation like that.
Thank you. Cross, Ms. Lehman?
Nothing wrong.
You should be excused, Your Honor.
Yes, you can step down and you're excused.
The next witness involves the exhibits that we spoke about earlier today.
Okay. So we have a little setup here. We are ahead of schedule, believe me. But there are certain things that need to be set up for your view. So we're going to take another break. Okay.
All eyes for the jury.
All right, and then you can take him down. You can take him down.
Your Honor, calling people versus James Crumbly, case number 22-279-989-FH.
Thank you. Good morning. Mark Keith on behalf of the people.
Karen McDonald on behalf of the people.
Good morning, Your Honor. Murray L. Lehman on behalf of James Crumbly, who is standing to my left.
We're gonna bring the jury in.
Thank you, Judge.
I was trying to beat the arrival of their lunch, so.
Ms. Williams, who's the TV is on? They have the volume turned up as well.
So this one is,
All rise for the jury.
all right, you may be seated. Prosecutor, who's the next witness?
Edward Rogowski, Judge.
Would you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth so help you God?
Yes, ma'am.
All right, you may be seated, and then would you state your name for the record and spell your first and last name?
Name is Edward Wogrowski, EDWARD. Last name is WAGROWSKI.
Go ahead, prosecutor.
Thank you. Sir, how are you employed?
I currently work with the U.S. Secret Service.
And what do you do there?
The title is a network intrusion forensic analyst. I do computer forensics, cell phone forensics, network intrusion stuff as well.
And how long have you been working with the United States Secret Service?
2 months now.
And prior to that, where did you work?
I worked with the Oakland County Sheriff's Office.
And what did you do there?
I was in the computer crimes unit.
Okay. So before, I take it you retired from the Sheriff's Office?
Yes, I did.
Okay, before retiring, how long did you spend there?
My entire time there was 28 years. I was in the computer crimes unit for 10 years.
Now, if you could tell us, please, what a detective with the Oakland County Sheriff's Office Computer Crimes Unit would do on a day-to-day basis.
On a day-to-day basis, our job was electronic evidence, whether it's a cell phone, computer, DVRs from a business, whatever it may be. We were the ones that handled that. We're the ones that had the training how to get the data from that or get the video from it or interpret call detail records.
Okay. So Exhibit 43, it's been admitted it's your CV. I'm not going to go through the whole thing. But is it fair to say that you've had specific training for your role there?
Yes, sir.
Okay, tell us about some of that.
The main training that we go to it with the sheriff's office was there's an organization called IASIS to become a certified forensic computer examiner. That has a 6-month testing process after 2 weeks of training at their training event once a year. On top of that, for cell phones, there's other agencies. Celebrate has training they do for the tools that we use from them, and other agencies as far as
Let me just interrupt you there. When you say Celebrate, what's that?
Oh, I'm sorry. Celebrate's a company, and they develop software and have tools to extract data from phones and then interpret that data.
How often in your employment with the Sheriff's Office and with Secret Service would you say that you actually analyze cell phones?
Almost every day. That's what we do.
So you went through a lot of, just now, a very quick rendition of detectives' work with the Computer Crimes Unit. I didn't catch most of that. Can you simplify a little bit of that for me?
I mean, so we get the data from the phones, and then we have to take that data and put it in a format that an officer in charge of a case, an OIC, is able to look at easily. Instead of sitting there scrolling through the phone, potentially changing data, we put it in a format, we take it off of there.
When you say data, what do you mean by data?
Everything on the phone, anything. Text messages, call logs, pictures, videos, anything that's on the phone.
So the goal as a detective, when you take somebody's phone, I take it that's via search warrant?
Via search or consent, yes.
Okay, so if there's a judicial authority for you to look inside the phone, then what do you do with it?
Depending on whether the phone is locked or not, we use methods to obtain the passcodes and then extract the data or the call logs and the messages and all that stuff. And then that's, like I said before, we put in a format that is easier to look at.
And what's the overarching goal of a detective in a computer crimes unit? What's the goal to obtain that information for?
What you want to obtain is all the evidence, if there is any, for prosecution. You want to make sure you get everything that is possibly on that phone to turn over to either the officer in charge of the case, who will turn over to the prosecutor's office.
Okay. So you're with the Secret Service now.
Yes.
In this field, the specific field, do you work with other agencies as well?
Yes, sir.
Tell us about that, please.
It's the same as with the sheriff's office. Any agency that reaches out that doesn't have the means to have the tools to get data off of phones, we just help them with it.
So we started to talk a little bit about your training in computer forensics. Have you been qualified as an expert in the past in this field?
Yes, I have.
How many times?
14 times.
In what areas?
Cell phone forensics, computer forensics, and then call detail record analysis.
Okay. What's called detailed record analysis?
Call detail records are what you get from your carrier. If you have AT&T or T-Mobile, via search warrant, you send a search warrant off to that carrier to get information with specific phone number, what towers they used, where the device might have been, stuff like that.
Okay. You mentioned cell sites.
And yeah, cell tower locations.
What's that mean?
The cell tower location is it's an antenna for your phone, sort of like it is for your car. They're all over the place, wherever, probably within a mile of each other, half mile of each other, depending on the population of the area. But it gives us the exact location where that cell tower is.
Okay. So in your over 10 years of experience working with the digital extraction of data from cell phones, would you say this field has changed?
Yes.
Okay. Is your training continuing?
Yes, sir, it does.
Why is that?
Well, just because the information changes, where an app might store information within the program itself, the little program might change on every update. So we have to know where we can go to find it if the tool can't find it for us.
Okay, when we say the tool, what's that mean?
The Celebrate software, either the physical analyzer software or other methods to get the information off the phone.
So then would it be fair to say that as technology has changed and evolved over time, so is the training of the computer crimes detective?
Yes, sir.
Okay. And is that training continuing?
Always.
So this time I'm going to move to qualify as witness as an expert in the field of cell phone forensics and historical cell site analysis.
Okay, he said computer forensics, cell phone forensics, car detail analysis. Are those the areas?
That's what he's been qualified in the past, called detail records, but in this particular case, he's going to be qualified as an expert in the field of cell phone forensics and historical cell site analysis. Judge.
Historical cell phone. Ms. Lehman?
No objection, Your Honor.
You may consider this witness as an expert in your historical cell phone analysis and cell phone forensic analysis.
Thank you, Judge. Cell site analysis.
Cell site.
Thank you, Judge. Sir, you mentioned that the overall goal is to extract as much information as possible. Would that be right?
That's correct.
Okay. So in a digital investigation, would you confine yourself to just the cell phone?
No.
Okay, so what other areas would you look for information?
Outside the cell phone, that the call detail record isn't stored in the phone. We have to reach out to the cell carrier. A particular app, whether it's Facebook Messenger or Instagram or whatever, we can search warrant them to get information for somebody's account.
Now, if you could tell the jury a little bit, please, about what a cell phone does that might not be commonly known.
When you're not using it, when you're not interacting with it and swiping up and down and stuff like that, it could be updating your email, because you don't always tell the phone to update, it just does it by itself. Or it's talking to a cell tower to know exactly where you might be in case it needs to send you a message, or it knows whether you're not in range or not, so the carrier knows to hold on to that message. There's a lot going on in the background that people just don't know the function's happening, but yet it's continually happening.
Is that while a phone's powered on?
Oh, yes.
Okay, so what happens if a phone's powered off?
Nothing. It can't do anything. It can't receive information, can't send information.
Okay. And what about Android phones specifically? Have you had the opportunity to be trained in data extraction from Android phones?
Yes, sir.
Okay. Is that the same as Apple phones? iPhones?
Not entirely. How the operating system is written, it's a little different in the process of getting the data off of the phones.
What do you mean?
On Android phones, it's a little bit easier to get the data off of a phone than it is an Apple phone.
You said operating system, what does that mean?
The main function, when you look at the phone, the main screen, that's like Windows for your computer, right? Or iOS for your Mac or whatever. The operating system is the base of that phone, whether it's Android or an Apple, which uses iOS, an Apple phone. That's the main thing that makes the phone function.
Okay, and I think you said that Android operates differently than Apple?
Yes, it does.
Okay, can you explain that to me again, please?
It operates a little different on how it stores data, how it retains that data, whether it's a file-based encryption, whether it's even encrypted at all, depending on the phone that you have, the manufacturer of that phone, and where it stores that data.
Now, were you able to obtain someone's locations based on the device?
You can, yes.
Tell me how that works.
The phone's always looking where you are. Obviously, it's talking with towers. The tower tells the phone where it's at. For advertising purposes, let's say Google, for example, they put those little cookies on your phone so it knows where you're at all the time, right? And it knows that you like going to Burger King. So every time your phone knows that it's near Burger King because the map app is being used, it's going to tell you, oh, there's a Burger King nearby, or it'll pop up in your Facebook message feed or whatever. So that's, yeah.
Right, cookies, what's that?
Those are little trackers, I guess, to make it simple. It's a little tracker that's embedded in however the phone interacts with either the internet or an application. It's a little nugget that just sits on your phone, waiting to be activated to tell either Google where you're at, Apple where you're at, and to give the user a better experience with their phone.
So if I'm on my phone and looking at a website, for example, and I get that little bar at the bottom that says this website uses cookies, accept or yes or no.
Yep.
So if I either hit yes or I close out of that box, then it's tracked on my phone.
If you hit yes, correct.
Okay. What if I hit no? What happens?
Then the cookies, they're not installed because you're not giving permission for them to be, loaded up to your phone, not installed, loaded to your phone.
So in order for me to look at the website, for example, though, I'd have to hit yes.
Not necessarily, no.
Okay.
No.
So this is something that as an investigator in this field, you're able to use to help understand the location of the device?
Correct, yes.
Okay, and tell me how that works though.
Well, like I said, one of the main things that we use is what's called location services. Location services is what tracks where your phone is within either an Apple or an Android phone. Google stores that data, again, because it sells that data to like Burger King or McDonald's, wherever the heck you might want to, whatever you're interested in. And it keeps track of where you have been, where you like to go to use that information in the future.
Okay. So I want to talk about specific to this case. I want to talk about some of the evidence that you reviewed in this case. First of all, were cell phones seized in the course of this investigation?
Yes, there was.
Okay. And you were the individual, you and members of your team had the opportunity to review those cell phones?
That's correct.
Okay. What about information from social media outlets?
Yes, we did.
Okay. Now regarding the cell phones, I'm going to summarize this. And I want you to tell me if this is accurate, okay? So source of electronic information from the shooter, a Android phone, T-Mobile phone, last four digits, 1551.
Correct, yep.
That's right?
Yes, sir.
Okay. A Facebook account, and an Instagram account.
That's correct.
Okay. Now regarding Jennifer Crumbly, there were 3 cell phone seized, is that right?
Correct.
Okay. So we have 2 from T-Mobile, with the same identical phone number, is that right? Okay. The TCL A509DL we refer to as a burner phone. What does that mean?
A burner phone is what we refer to. It's a phone that you can go to Walmart in the electronics section where they sell their TVs or any CVS or Rite Aid and just buy it in the packaging and activate it. The SIM card's in there, and there's really no account that's needed to get it up and going. You just activate the phone by putting money towards the account within it.
Okay. A Facebook account, jehn.crumbly.7, and includes the messenger functions. What do you mean by that?
So Facebook Messenger and Facebook, separate. It's 2 separate platforms. But you can search warrant Facebook for Messenger information, or you just search warrant for Messenger information.
Okay. And then we have certain emails account from Gmail and Yahoo.
Correct.
All right. And then Instagram account, JEHNC78.
Correct.
So regarding James Crumbly, again, 3 phones were seized, 2 of which were T-Mobile phones with the same phone number, and the third being the TCL 8509DL burner phone.
Correct.
Okay. 1 Instagram account, James R. Crumbly. 1 Facebook account, which included the messenger function, James R. Crumbly, and Yahoo, Gmail, Charter Communications email accounts.
Correct.
Okay, and then DoorDash search warrant for James Crumbly. So was the search warrant issued to DoorDash?
Yes, it was.
Okay, was information received?
Yes, it was.
Okay, so we spoke about that very briefly early. A search warrant is when a judge or magistrate authorizes a document to a social media provider or a company, for example, and information is returned.
Correct.
Okay, and so what happens when you get that return?
Sometimes it's in an easy format. It's just a simple Excel spreadsheet. Other times it's multiple Excel spreadsheets that you have to compare different parts of that 2 spreadsheets to come up with the information.
Okay. Thank you very much. Now, your role normally would be to talk about cell phones, computers, cell towers, things like that.
Correct.
So with your permission, I'd like to talk to you about November the 30th, 2021. Do you remember that day?
Yes.
You were working for the sheriff's office?
Yes, I was.
And you were computer science.
Yes, I was.
Were you working that day?
Yes.
12:50, 12:51 in the afternoon on November the 30th. Do you remember where you were?
It's probably driving pretty fast.
And tell me why.
We got news from our captain that there was a shooting at the Oxford High School. Prior to that, we, our sergeant who was off that day, reached out, texted one of the guys in the office and said there was a shooting at the high school, and nobody believed it. Like, we believed it, but we're like, that's just somebody nearby at a house, you know, fired off a rifle or something, and the police are gonna go do their job. And then a couple minutes go by. And the captain comes in and he said, there's been a shooting at the high school, and he said, all hands on deck.
Okay. What did you take that to mean?
There's a shooting, like, it was,
All hands on deck. You're not normally somebody who responds to active shooter situations, right?
no, it's for the nerds. No. When, for the captain to come to the computer crimes office, that was, all due respect to the guys in there and the gals in there, that's not their job to deal with that. The fact that he came in there it was a really big deal.
Okay. And you mentioned you were driving pretty fast. Tell me about that.
I remember getting out to my car. At the time, I had a white minivan that had lights and siren in it. No one ever took it seriously when we turned the lights and siren on. But I remember pulling out of the parking lot, and I looked to my left, and there's, it didn't seem real. It didn't seem like this. Like, I'm thinking in my head, like, this is just blown out of proportion, because I didn't have my radio on in the car. I couldn't hear the radio traffic at the time. And I looked to my left, and there's 2 patrol cars, not even from our agency, not even from the sheriff's office, coming around the far corner on this complex by the medical examiner's office and the animal control. And they turned that corner on 2 wheels on each side, on the back, coming around that corner. Their lights were shining. They were going fast. And I'm like, holy cow, this is real. So then I turned my lights on because I just thought we'd get there and do what computer crimes does, you know? We would do our thing. And I turned my lights on, the siren, and I started going north towards Walton. Telegraph runs up the wall, and it cuts over to M20, US 24. Telegraph cuts up to Walton, and it goes over to M24. And I had no idea where the heck I was going. I've been to Oxford for a half a second driving through. And I thought, well, I remember thinking when I get there, I'll just follow the crowd because it's going to be big. And going north on 24, and I see see one of our SWAT vehicles going across that bridge from 75 down to 24. And the light was red for me. And I thought, well, I'm gonna have to slow down. Like there's cars coming down the ramp. I remember getting closer and closer thinking, how come nobody's going? Like my light's red, this cross traffic should be going. Like, because as a police officer, obviously when you run a red light, it's extremely dangerous. You don't do it haphazardly. And I'm approaching this light thinking I'm gonna have to slow down. And as I get to the light, I look over and there's a patrol car just sitting. I don't know what agency they work for. And so I go through that intersection and then I see them join up behind me. And then I see 2 other patrol cars from another agency coming up behind me. I remember, I don't know if it was Brown Road or what the next major crossroad up the hill there. I remember the light was red and there were cars stopped in both lanes. And I thought to myself, I'm gonna have to go onto the shoulder. And so I'm looking at the shoulder thinking, I mean, it's part dirt. It's a small shoulder of asphalt and dirt, and my small tires on that minivan, it's not going to handle well, but we're not going to stop going, right? So I remember feeling the steering wheel shaking from the gravel, and I get around and keep driving north. Crowd still following me. I look up in the mirror every once in a while, and there had to been, I couldn't count them. They were so far deep behind me, and the ambulances and the SWAT vehicle. And we get up into town, up into Oxford, I think we were. And as I'm approaching the light, it just changes red. So obviously cross traffic doesn't know what's going on there. You might just have somebody that just goes straight. And again, it's dangerous. It really is. And so with the lead car, I've always been told the lead car in a situation like that, you always hold that intersection for everybody else behind you because they're coming. And so as I inch into the intersection, I stopped dead in the intersection with the lights and siren going. And I counted at least 16 vehicles just go screaming past me. And we start getting into town and northbound traffic's blocked. It's dead stopped. I remember going against oncoming traffic. And now you see cars coming at you, and you're the whole way there. All I could hear on the radio was staging area on Ray Road in Meyer. That's what I kept on hearing. There was so much radio traffic. I heard bits and pieces of other things, but that really stuck in my head. And so we're just driving north, and finally I just see a Meyer, and I'm like, okay, well, we got to be far enough north. This is where I got to go. And so I pull up onto Ray Road, and I meet up with other deputies in the area.
If you could describe to us what you saw when you arrived at that Meyer.
That was tough. That was really tough. I got a daughter who, she's 17, 18 years old, and 17-year-olds, they wear those tight leggings and all that stuff and small shirts or whatever. I remember standing there on Ray Road, and I see these kids. One kid didn't even have a shoe on. He only had one shoe on. Walking through the snowbank, going down to the Meyer. And I see these girls dressed like my daughter. And it was cold that day. I had 2 coats on, and I was shaking. I was shivering. It was so cold. I remember offering one of our lieutenants at the time. He didn't have a coat. I offered one of my coats because I was so cold, and he didn't take it. But you just saw these kids just coming down from where the school was. Like, it's hard to describe. They look like zombies. Like they had no facial expression, nothing.
So there were kids there. Were their parents at the Meyer too?
Down by the garden center. But the crowd was heading that way, and it was chaos. It really was. I really didn't know what to do once I got there. I didn't know where the school was, even though it was just up the street. So everybody was walking to the garden center, so I started going that way. And at first, we were told to start getting people to sign their name into notebooks. We were just grabbing them off the shelves in the Meyer and boxes of pens and stuff, and just write their names in the notebooks for whatever. I don't know why they needed that. So I'm trying to walk around and get this information from people. And then they start yelling. Someone starts yelling, get everybody inside, get everybody inside. So I go back outside to try to usher people in. And I remember just seeing like kids just standing there and you put your arm on them. You don't want to, they just been through this, whatever happened up there. And I don't want to force them. I'm not going to grab them. I'm not going to make them do anything they don't want to do. So I sort of like, if they didn't move, I just left them. They were okay. They weren't in harm's way. I remember seeing parents just standing there because these school buses started arriving. And I remember thinking in my head, like, God, that is just crazy. Why in the heck are there school buses? I didn't know anything about the plan if something like this happened at the school. And so, and I just see the parents, like, you see them just almost praying in their head that their kid came off the bus.
After you helped with the names and the notebooks, did you go to the school?
Yes, I did.
And were you directed to go to school, or did you just know that's where you were needed?
No, one of the other detectives, Jeff Enger, he responded to the school and he called me on my phone and said they were trying to get the video from the surveillance cameras in the school. And at the time, I was a little more versed in that side of the job. And so he just wanted a little help with that.
Okay. So tell me about, you arrived at the school. Where did you initially go?
I went to what would be the north side of the school. There's a big circle drive there. And it's the side that like the main office is on of the school. Again, there were patrol cars everywhere. There were everybody everywhere. I remember driving up over the sidewalk, thinking, I remember like the stuff I remembered, like the sidewalk being so high, I thought it was gonna rip the muffler off my car. I don't know why I thought about that. And I go up over the sidewalk and I just stopped my car because that's what it seemed like everybody was doing. And I walk in the door and one of our sergeants is standing there, providing security just for that door so people aren't coming in. They shouldn't be coming in or whatever. And I asked him where the security office was because that's where Detective Enger told me he was. And pointed me to the office, and people eventually pointed me back to the security office.
Okay. And who did you encounter when you went there?
As I walked in, I remember seeing the security officer, Jim Rourke, was in there. Deputy Jason Lewert was there. I didn't know him at the time. ATF agent Brett Brandon was in the room.
Right here behind.
Yep. And Lieutenant Marsban was in the room.
And you said at that point you were called over to help with the security footage.
That's correct.
Okay, so tell me what your role was at that time.
Obviously the bosses are going to want to know what happened, where it started, all that information. And I wasn't given any direction. We weren't given direction, but we just had to figure out when it started, where it started, how it started, as much as we can, because they're going to want to know that information. And so we just started reviewing video footage.
At that point in time, was the high school still being cleared?
Yes, it was.
Okay. And when I say being cleared, we haven't had another officer testify yet. What does that mean?
To clear something, you're going to look for more bad guys. You're going to look for maybe bombs that might have been placed. Someone hiding in a room because they know the police are there, so they're checking every room, every closet, everything in a high school, going door by door, checking it all.
So tell me how it is that you went about your job that you were called there to do that day.
Jim Rourke, like I said, he was the head of security. And they had a system where you didn't actually interact with the DVR system itself. You interacted through a portal, a web page, to access the server where the video was stored at. And thank goodness he was very well versed in that. So I immediately, I told him, I said, well, you got to help me figure this out because I don't know what's going on here. So Jim and I sat there, went to the hallway that it started, and try to determine at what time the shooter went in there.
So how many cameras approximately did Oxford High School have equipped for surveillance footage?
Oh, they have at least 100 cameras.
Okay. And it was your responsibility to review that footage?
Yes, it was.
Judge, this might be time for a natural break.
Oh, all right. Well, the jury's lunch is here. So that would probably work. I'm not sure if I call you sergeant, detective, lieutenant, Mr., hey you, none of those?
That's fine.
Okay, all right. You should not discuss your testimony because you're still on the stand right now, so please don't discuss your testimony with anyone,
Yes, ma'am.
all right? So you can step down. If I give you till 1:15, is that enough? Yeah, okay, those who ordered lunches, your lunches are here, all right? Do not discuss the case with anyone, don't text anyone, right? Okay. All right.
All rise for the jury.
All right, you can take them down.
The court prepared for ruling on exhibits 133, 153. They would be through this officer's.
Okay, all right, I will take care of that, all right? I'm all right. You should not discuss your testimony because you're still on the stand right now, so please don't discuss your testimony with anyone. All right, so you can step down. If I give you till 1:15, is that okay? Yeah. Okay, those who ordered lunches, your lunches are here, all right? Do not discuss the case with anyone, don't text anyone, right? Okay. All right.
All rise for the jury.
All right, you can take it down.
The court prepared for ruling on exhibits 133, 153. They would be through this officer's.
Okay, all right. I will take care of that. All right? I'm trying to hit, I don't want to lose the jury until he's.
Yes, sir.